don't really know what to say other than I'm real sorry to everybody affected, the family, and just everything that's been a consequence of what I've done to y'all. I'm gonna have to live with what I've done for the rest of my life, absolutely, and I wish I could take it back. I apologize to y'all, to everybody here today, bring this here. Thank you, Your Honor.
All right, Mr. General. All right, well, I think that concludes the recommendations and statements, and so it's up to the court now to make a determination in this case. Mr. General, there are a lot of interested parties here in the courtroom on both sides, family members and friends on behalf of the victim and family members and friends on behalf of the defendant, and those are always very important and competing interests. And that's why our judicial system works, I guess, as well as it should work, is that we have input from both sides of the case, the state and the defendant, family members on behalf of the victim and family members on behalf of the defendant, and the court is then given the responsibility of arriving what would be an appropriate sentence or disposition of the case. And that's not an easy task. As I undertake that task, I first obviously start with reading everything I can in the file, reading the pre-sentence reports, understanding the facts and circumstances of the crime. That's what the 19-2521 directs me to do. That's a statute in the state of Idaho that gives the court some guidance on how I'm going to evaluate these cases and arrive at a decision. So I do want to understand the facts and circumstances of the case, and I've had some discussion about that further here in the court. I think there's a lot of maybe still unanswered questions to a certain extent, but the court is relying upon what I've been given in the pre-sentence report and what I've been told here in court today. As part of reviewing all that information, that's all contained in the pre-sentence report and the police reports that are attached. And I also obviously want to then understand the history and characteristics of you, Mr. Gentle, as an individual defendant. And that's also information that's in the pre-sentence report telling me about any prior record you may have, which you really don't have much of prior record other than a DUI, which is not to be minimized, but you have a misdemeanor DUI in your prior record, but don't have anything other than that. I think that occurred when you were 19, as I recall. This is obviously a first felony offense, but it's obviously a very serious felony offense. The letters from your, so I guess as I was indicating, I read through the history and characteristics or the facts and circumstances of what happened, and obviously there are a lot of very aggravating factors there of what the circumstances of what happened and the loss of life, the death of Mr. Sorensen. And I can start heading down one road of what I think ought to happen in your case, and considering the state's recommendation of 15 years fixed seems like what the court should do. Then I read the other side, the history and characteristics of you and family and friends who have written on your behalf to try to tell a story about who you are when you're not under the influence of drugs. And that's what this case really is about the ravages of drug addiction and what it does to people. And I agree with Mr. Archibald that that's something we fight in the courts every day. Probably 90% of the cases I handle in court are all drug cases that we try to work through with people that are dealing with drug addictions to avoid what's happened in this case. I mean, that's why we do that, is because this is what happens when people have drug addictions and don't get involved in appropriate treatment or intervention, and You end up with a tragedy and a loss of life. And so drug use is not a victimless crime, as people sometimes try to portray it. There are many victims of drug usage, and this is the obvious situation where there is an obvious victim. So I try to go through and weigh all those differing factors, and Idaho Code Section 19-2521 tells the court that in any case, not just this case, but in any case, that I'm to first determine if a community-based treatment would be appropriate. In other words, whether probation would be appropriate. That's contained in subparagraph 2A through J of that code section. And the court has reviewed all of those provisions and finds that probation or community-based treatment or sentence would not be appropriate. And I think that by the defendant's own stipulation and sentencing recommendation, they have also agreed that those factors do not weigh in favor of avoiding incarceration, and that incarceration has to be imposed in this case. So we next determine and help the court in arriving if we're going to impose incarceration, what the length of that incarceration should be, or the nature. And those are contained in subparagraphs 3A through E of that code section. The first of those is that without a sentence of imprisonment, that there is a undue risk of harm to the public, or that the defendant may commit another crime. And I'll get to the mitigating issues in the family letters, but I'm just pointing out, I think here, really initially, the aggravating factors in the case, that there obviously is an undue risk of harm to the public if Mr. Gentle is not incarcerated. I think, as I've indicated, the risks and the harm related to drug usage is apparent. I think there's a significant risk of Mr. Gentle potentially reoffending because of his ongoing drug use and substance abuse, his admitted daily use and purchase of controlled substances creates a clear danger to the public that I think has to be dealt with by incarceration. In this case, there was a total disregard for life, and in effect, it appears at first glance and reading a clear premeditation, but you haven't pled guilty to a crime involving premeditation. But the court feels it's a factor that I can consider. You went and retrieved a gun by the accounts. 2 shots were fired, not 1. I think there was just a total disregard for life in that particular moment. In the state of mind that you're in, you're engaging in a lot of erratic and dangerous behavior while you're involved with drugs, and by some accounts have a severe anger management issue that needs to be addressed. So I think that clearly warrants incarceration, and it's really just a determination of what length of incarceration. The second factor under that provision is that a sentence of less than incarceration would depreciate the seriousness of the crime. Obviously, this is a serious crime. The potential sentence is the court is limited by up to 15 years in prison. That's the maximum sentence the court is allowed by law to impose in this case. At first impression, it would appear that is the appropriate sentence of 15 years in prison. And I have to get to the other factors that I'm going to consider. I've already talked about appears to be appropriate. As is stated, the other factor for the court is a sentence of imprisonment is necessary for punishment to you for that wrongdoing, just punishment for punishment's sakes, for the act that you committed. There is a price to pay for you as well. You can't pay the same price as Mr. Sorensen, but there is a price to pay. Deterrence to you and to others, there's arguably whether that's really effective, that whatever I do here in this courtroom is going to deter anybody else, or even deter you in the future. But I do think that a message needs to go out to those that are using drugs. If they're become aware of what happened in this case, that drug usage is dangerous to the public and to themselves, and that these kind of tragedies can occur, and if they continue down that path, that they themselves may find themselves sitting in the same chair that you are, subject to going to prison for a long period of time. And it just points out the, as we've indicated, just the ravages of drug usage and addiction that we try to deal with, but in this case apparently have failed, and unfortunately someone has lost their life. So I have to consider that in determining the length of the sentence to impose. The other characteristics of you individually, Mr. General, are what I might refer to as mitigation factors. You're 22 years of age. As I've indicated, you have no prior felony record. You really have a minimal misdemeanor record. You appear to be remorseful for what has happened here. That's a difficult thing to portray, but I think there is certainly sufficient information that the court is satisfied that you are remorseful. I think you've changed a lot in the last year. You've been in custody, not subject to daily use of methamphetamine. Although, maybe point out that apparently there was an incident of you attempting to make alcohol in the jail and had some sanction imposed against you for that, which again I think just points to the addiction issue, that you're still willing to violate the rules in a correctional facility just to feed the addiction. I've used your daily use of controlled substances as an aggravating factor, but it's argued as a mitigating factor too, that you simply weren't thinking clearly, that this event would never have happened but for those drugs in your system and your brain just not functioning, and that I should take that into consideration. Your efforts at treatment, I think you'd had some efforts back in 2015 and 2017 for some outpatient treatments that apparently either weren't followed up with or obviously were not effective because you continued using. To your credit, it sounds like, and your family indicated you tried to go to the Walker Center in 2018, which is a good program. Your grandfather had loaned you quite a bit of money to go to that program. Unfortunately, it appears that your insurance company changed their mind, decided they couldn't cover the $40,000 cost, and so you had to leave the program. So I guess that's not really your fault. It's just another problem with our system and our ability to get people into treatment programs sometimes is the costs associated with those programs. But I only point that out because I do find that you at least tried to make some efforts for treatment, but you quickly, after you left the Walker Center, just went back to your old lifestyle and started using and continued to use. The family letters, as I've already stated, family and friends, I have them all in front of me. I don't want to miss anybody, but obviously your grandfather, your mother, your other relatives and former employers, your employer from the city of RIGBY, the employer you had over in Wyoming, all written very positive letters regarding your character, your work ethic, growing up as a young person, and what kind of a person you were growing up paints a very different picture than what happened in this case, and it's sometimes difficult to reconcile how someone with that kind of a personality growing up could get involved and do something like we're here in court for today. But again, it's just, I don't know how to reconcile it other than the drugs. But the drugs can't be used as an excuse anymore. There just has to be a penalty for what's happened and the continued use. So, Mr. General, I've considered all of those facts and circumstances, your history and characteristics, and considered the sentencing criteria in Idaho Code Section 19-2521. If you please stand, Mr. General, so the court can impose the sentence. You pleaded guilty to the charge of voluntary manslaughter. Finds you are are guilty of that charge. It's a sentence of the court that it's a two-part sentence that we impose in the state of Idaho. You'll be sentenced to a total term of 15 years, which is the maximum sentence allowed by the statute. I've weighed the arguments on both sides of this case. I think there's some merit to the idea of you being eligible for parole at some point in time, so upon release you could be supervised for at least a brief period of time and given some of the resources of supervision. It also gives the Department of Corrections an inmate who has an incentive to behave themselves in prison so they can present themselves in a positive light to the parole board, because they have hope of parole. An inmate with a fixed term with no possibility of parole is an inmate that's very difficult to deal with in the penitentiary system. And so that's one of my considerations and thoughts of why I am going to give you some indeterminate time here on this sentence. So I'm going to impose a fixed term of 12 years with a 3-year indeterminate period to follow. That's somewhat of a compromise between what the state is asking for and what you have asked for the court to do. I frankly just had to walk myself back from the 15 years fixed to give consideration to the letters I received from your family and my other considerations to walk it back somewhat to that 12 years fixed. You'll have then the potential of parole after 12 years. It'll be up to the parole board based upon your performance while you're in custody, whether they're going to grant that parole. And if you go over there and engage in conduct violating their rules or having problems, then you'll spend the 15 years. If you go over there with some attitude to get in a positive state of mind and take advantage of programs, then you potentially could get out and be on parole. I'm required by law to give you credit for the time that you served in the Jefferson County Jail against that time. That's also one of my considerations of why I'm giving some indeterminate time on this sentence, is that I consider time in a local county jail a somewhat really hard time. It's maximum security time in a very small secured facility with not much opportunity to be out and get any kind of exercise or as you do in a prison setting. When you're in prison, you can get out and move around and have more opportunities, whereas in a local county jail, you're in very close quarters with not much opportunity that way in any jail, not just Jefferson County. So I consider local jail time as a little harder time, so I'm giving you a little bit of credit for that. That's why I'm also giving you this 3-year indeterminate period. In this case, I'm going to require you to pay court costs that are required by law. The restitution issue we're going to leave to be decided at a later time. I always require reimbursement to the county for court-appointed counsel in this case, and I'm going to impose $1,000. That's obviously just a minimal amount. There's much more work than that done in this case, but that's an amount that I just impose in any matter, in any case of this nature. Typically it's $500, but I've just doubled that in this particular case. The other financial impacts here, we've talked about restitution. There is a provision under Idaho Code 19-5307 for compensating the victims in homicide cases, and it applies to manslaughter cases as well. That can be a compensation amount in the amount up to $5,000. It's not restitution specific to any particular expenses. It's simply money paid to the family of the victim. In this particular case, I'm going to impose $5,000, but I'm not quite sure who to order that to be in favor of, because there are a lot of family members. We've had two nephews speak here today. We obviously have the stepdaughters that I've already ruled that maybe not qualify technically as victims to be entitled to those funds, but I do think there ought to be some financial compensation here as part of my decision to grant that indeterminate time as well. And I don't want any of your family, Mr. Gentle, to have to pay that. I think that's something that you need to pay when you're released or when or otherwise. So I'm going to order that. I'm going to reserve the names, I guess, who that's going to be awarded to. And Mr. Stavinsky, I guess I'd ask the state to submit to the court some proposals as to victim family members as identified under the statute, the victim statute, that should be able to split those funds some manner. Mr. Archibald?
Your Honor, may I suggest just the estate of Jay Sorensen? There was a probate file, and if it goes to the estate, then they can figure out who gets it.
Well, I thought about that, but I also just didn't know if Mr. Sorensen had a will, and his will may, money may go to individuals he willed the monies to. I guess that's a consideration. If the state wants me to just have it be ordered to the estate of Mr. Sorensen, I can consider doing that, or to individual family members, but I appreciate that recommendation. The actual restitution that we've discussed that's been submitted, we'll reserve that for further determination. I've already indicated my preliminary determination ruling that I will grant funeral expenses, and I'm not going to require the estate to pay the funeral expenses or reimburse Mr. Martin, the nephew, for those expenses. I think the defendant, Mr. Gentle, should be responsible for those. We just need to determine those amounts, and if there's any other contested amounts, we can have further hearing on that as well. So Mr. Gentle, first of all, I guess Mr. Stavinsky, have I overlooked anything in my sentence at this point?
No, Your Honor, thank you.
All right, Mr. Gentle, that is the order of the court. The sentence that I have imposed, you do have a right to appeal my decision today. You have 42 days from today's date to file that appeal. You also have a right to ask me to reconsider the sentence I've imposed today. Under Rule 35 of the Idaho Criminal Rules, you must file that motion within 120 days of today's date, or 4 months from today's date. You also have certain rights under Idaho's post-conviction relief statutes. If you feel your rights, your constitutional rights or otherwise, have been violated in some way during the course of these proceedings, you have rights under the post-conviction relief action to bring an action as a plaintiff alleging violation of those rights, and there are certain things you have to do to comply with that and file that action. There are time limits for filing that action. You would have 1 year if you do not file an appeal. You have 1 year from the time for appeal expiring. So 42 days from now, you have 1 year from that date to file a post-conviction relief action. If you do file a post-conviction relief action, then, if you do file an appeal, then you have 1 year from the time that appeal is finalized by the Idaho Supreme Court to file any post-conviction relief. So it differs whether you file an appeal or don't file an appeal. So do you understand those rights, Mr. General, and the time limits?
Yes, sir.
All right, and both attorneys can answer any questions that you may have in that regard as well. And both Mr. Archibald and Mr. Stosich will remain on as appointed counsel of record for you until your time for appeal and your time for a Rule 35 motion may expire, at least until that point in time. So, Mr. Archibald or Mr. Stosich, anything I've overlooked or any questions?
No, thank you. On the issue, we did ask if his family could have a contact visit with him before his transport to Boise. I understood the court to say, I'll leave that up to the sheriff.
Yes, that's correct. I have that request made to me on occasion, and those are matters of security within the jail and the courtroom security, and I don't feel like I'm in a position to direct the Jefferson County Sheriff how to run their facility and to tell them to grant those kind of contact visits. So I have to leave that up to the Jefferson County Sheriff Department. I personally have no objection to it, but I'm going to leave it up to the jail to determine if that can be allowed. Anything else?
No, thank you.
All right. Mr. Gentle, you're committed to the custody of the Jefferson County Sheriff to be delivered to the Idaho Department of Corrections to serve this sentence. I wish you the best of luck in the future. You may go ahead and be excused, and we'll be